We now have Arshia Tabrizi to talk about the term sheet. That's when guys agree to give you the check. Arshia is the founding and managing partner of Tabrizi Law Office. He's technology lawyer, a business and intellectual property lawyer in one. He's a computer engineer and former technology transaction attorney at renowned Silicon Valley law firm Wilson, Sonsini, Goodrich, and Rosati. Arshia specializes in technology law and transactions, licensing, startup, corporate matters, venture capital financing, internet and e-commerce law, as well as intellectual property counseling and strategy. His clients are drawn from various sectors including software, semiconductor, communication, mobile, semiconductor, nanotechnology, clean tech, green tech, internet, and e-commerce. What's left, Arshia? Please help me welcome Arshia Tabrizi.
Okay, all right. Well, so the first thing, I guess, if you're dealing with a term sheet, is congratulations, right? Because you may have heard one of the previous speakers, I think, from the IAF at Mars. If you're looking to raise money, you want to start about a year ahead. Hopefully, it would not have taken you a year to get to the term sheet stage, but regardless, it would have been at least, I think, weeks or a month of pitches. So the term sheet is good news. Basically means you have an investor who's presented you with this piece of paper, and they're willing to actually put money into your company. I guess the slight bad news is that you're not fully there yet. And I'll talk a little bit more about the process of a term sheet. But first of all, what is actually a term sheet? So in the venture financing context, we talk about a term sheet, but if you're dealing with any kind of transaction or agreement or contract that you're looking to enter into, you'll also hear the terms LOI, letter of intent, or MOU, memorandum of understanding. Essentially, a term sheet is kind of a neat legal creation, right? I mean, these LOIs, these things are neat legal creations. Because what you have is you have something that is a contract, but it's actually not a contract. Now, what do I mean by that? We'll talk a little bit more about the breakdown of the term sheet provisions. But basically, what I want you guys to take away from this point around the term sheet is that even if you sign on the dotted line, so you get this term sheet, has a signature of the VC or the angel or IAF on it, and you sign on it and you accept, that doesn't necessarily mean that you've created a legally binding contract under which you can actually sue the investor and essentially force them to invest in your company. So now let's talk a little bit more about what I mean by it being a contract and not a contract. So the term sheet essentially is the investor's offer on paper. Now, you'll see, and I don't think any of the previous speakers actually spoke about this, but you'll see different kinds of investors, whether it be angels or institutional investors, who present different forms of term sheet. So I have seen things which are very, very loose, high level, like 1 to 2 page type documents. And I've also seen large financing rounds with 15 to 20 page term sheets. And those are very, very detailed. So you'll see essentially varying degrees of detail on deal terms in these kinds of documents. I made a little point there in terms of a company offering, and the only thing I wanted to mention is that what I'm talking about from a term sheet perspective is something that's put on paper by the investor and presented to you as the company. There are scenarios in which a company, and even an early stage company, might actually do an offering and present some terms which they would circulate to a variety of investors. But in a venture context, primarily, that's what we're talking about, an investor presented term sheet. So going back to my previous point in terms of, you've received this thing, it's good news, but you're not there yet. So there's still some steps to go through. The first point I wanted to talk about in terms of the term sheet process is that different investors, again, have different practices in terms of when they would present a term sheet. And that actually ties in as well to where you are in terms of your discussions with that investor and how detailed the term sheet will be. So I've seen investors which will very early in discussions start to present a draft term sheet. So in other words, it's kind of like this is a document that's putting at a very high level what we think the deal terms might look like. Let's take a look at it, let's discuss it, and then that draft kind of goes back and forth, and you guys talk about it verbally over several weeks before it actually comes to a stage where it's a final offer from the investor to the company. Other investors will spend a lot of time up front doing the due diligence. They will not present you with a term sheet, and they will have discussions with you around various deal terms, but when the term sheet actually comes, they're basically expecting the vast majority of the deal terms to be there, and they're expecting you to basically sign on the dotted line and return to it. One of the key points I wanted to mention here, of course, is that in a primary deal term for any kind of investment is what's the valuation, right? And we heard Suresh talk about that. And essentially, a valuation is going to set how much of the percentage of the company you're going to give up in return for that investment. And so when I talk about the term sheet coming in earlier or later in the financing process, you'll actually see, I've seen term sheets where even the valuation is still under discussion, but there's a draft term sheet circulating. So that's how early the document comes into play. I already talked about that other point. The final point there too is in terms of the turnaround on a term sheet. So again, I'm talking about typically, right? So typically 48 hours to sign back. Having said that, that's not always the case, right? There are, typically the investor will present the term sheet and they'll say, okay, here it is, Monday morning. We've spent, weeks with you guys in due diligence. Here is our term sheet. These are our deal terms. Take a look at it, review it with your advisors, with your lawyers, and we basically expect you to sign back by Wednesday, end of day, if you really want to do this deal, right? Doesn't necessarily mean it happens in 48 hours, but let me tell you that, and different investors, even on the institutional side, have different, approaches to term sheets and the process and how heavy-handed they are about it. But regardless, the later you go in terms of the spectrum, so when Matt was talking about micro VC and the sort of later stage VC, the larger and more established and institutional the investor is, the more this thing becomes true, right? So now you're talking about some serious money, and they're going to put the pressure on you to essentially sign off and close at least on the term sheet. So I'm going to talk a little bit about this whole notion of a term sheet being a contract, but at the same time not being a contract. And so what I'm going to do is I'm going to spend some time talking about what we refer to as the binding provisions. Okay, so in other words, certain sections or certain terms in the term sheet result in an actual contract. And when I say contract, I mean a legally enforceable contract in a court, right? And some of them don't. So typically the binding provisions in most of these venture term sheets are fairly limited, and what you're really looking at is, and I'll go through them one by one. The first one is confidentiality. So you'll always see in these term sheets essentially a provision that says, and it works for both sides, it's a mutual confidentiality obligation. And essentially it says, these discussions are going to be confidential. To the extent after we sign this term sheet or prior to the term sheet, we may have had, as the investors, access to certain information about the company, we're going to keep this confidential. Now, there may be times where actually the investor and the company may have actually executed an NDA, and I'm sure you guys know what an NDA is, non-disclosure agreement. But typically, I'd say all cases pretty much with institutional VCs, they don't sign NDAs. So the only time you're going to be dealing with actually confidentiality obligations would be in the term sheet stage. The other provision that you'll see that is referred to as a binding provision, in other words, creates an actual contractual obligation between the investor and the company, is the exclusivity provision. Now, the exclusivity provision basically is there to protect the investor from having spent this whole time to generate this term sheet, presenting you this offer, you signing back the term sheet and saying, well, thank you very much. I really love these deal terms. Thank you for giving me this fantastic valuation. And yes, we're going to continue to do this due diligence until we actually close the deal, which I'll talk about later because this is not the closing. It's just the start of the process. But in the meantime, I'm going to go talk to a whole bunch of other investors and see, maybe I can get a better deal. The investor doesn't want that. They don't want to spend, another month obviously working with you towards a deal and then find out, the 11th hour, well, sorry, guys, I actually got a better deal somewhere else. So that's what the exclusivity provision is about. Essentially saying you're not going to talk to anybody else during a certain period of time. And typically the exclusivity provision is anywhere between 45 to 90 days depending on the size of the deal, etc. And then the other thing too that you'll see is a cost provision, and sometimes VCs will actually ask the company to pay for their legal costs, whether the deal closes or not. Okay, some of these things can be negotiated. You can negotiate cap on legal costs, but the basic idea there is that each party at least should be responsible for their own legal costs. But again, sometimes the investors will ask you to cover their costs as well. So now you've seen, you probably are thinking, hold on, so those things that you talked about and you told me were binding provisions, those are actually not the key things that I'd be looking for in a term sheet. So what are you telling me here? What I'm telling you is that the term sheet basically, where it's dealing with actually the key things that as a company you care about, the actually meaty parts of it, they actually are not resulting in a contractual obligation. And the reason, what's the reason for that? The reason for that is the term sheet is essentially an expression of interest, or an expression of, these are the general deal terms that we as the investor feel we would like to do a deal with you on, but we still are going to be continuing our due diligence on you. We might be doing management interviews, we're going to look at your books, we're going to do this and that, and we don't want to be bound. If for whatever reason we decide we don't want to actually do this deal, we don't want to be in a situation where you could sue us on this offer. So that's sometimes a bit of a surprise to companies, right? But I just want you to understand that. And what are some of the key provisions around the deal terms which are not binding, right? And this will actually take us through some of the key provisions in general in the terms. Obviously, the first thing, the investment amount, right? So what are you actually proposing to invest in the company? Now, this can also be a tricky thing. You'll see some term sheets, and this is not the case for institutional guys, but sometimes, for example, if you're dealing with angels who are trying to syndicate the deal with a number of other investors, they'll present a term sheet to you and they'll say, yeah, anywhere between $200,000 to $1 million. That's our investment amount, right? Of course, as a company, it's very difficult to understand what that actually means. Right? But what are you actually committing to, right? So that's something you want to watch for. I mean, you'll see terms like up to $1 million, up to $2 million. What does that mean, right? Tell me what is actually committed so I can actually understand what I'm getting into. The other thing you'll see in term sheets, and this again is fairly typical. Well, I wouldn't say typical, but in a lot of cases you'll see this both from in terms of angel deals as well as venture deals, is tranches or milestone-based investment, right? So in other words, they'll come in, get a group of angels, they'll come in and they'll say, okay, I'm going to commit to invest in $500,000 in your company at this valuation, but I'm not going to give you the $500,000. I mean, Suresh, I think, alluded to that kind of a deal structure. I'm not going to commit to the $500,000 up front because I feel like there's still some things that you need to prove for me to commit to that full amount. So what I'm going to do is I'm going to say, okay, we'll agree on this valuation. I'm going to put in $100,000 today when we close, or not today, once we sign the closing documents. I'll put in $100,000, and then 6 months later, if you show to me that this $100,000 has taken you to create this additional value in the company, I'll put in another $200,000. And then 6 months later, when you get to this other milestone, let's say X number of clients or this growth in user base or growth in revenue, then I'll put in the other $200,000, right? So again, these are things that are important for you to sort of look at and understand at the term sheet level, because you might think you're doing a $500,000 deal, but as company counsel, I always tell my clients that you're doing a $100,000 deal with a contingent for $100,000 after that, right? And of course, the other thing is the whole valuation, right? So these investment amounts, at what valuation are they happening, and what valuation are they sending the company? So how much are you going to be giving up? The other point that will impact basically how you evaluate this proposed investment or proposed term sheet from the investor is, well, what class of shares? In other words, if they're doing an equity investment, what class of shares are they going to take in the company? And when I talk about class of shares, typically in an institutional round, or even with some of these micro VCs, you'll be looking at a preferred share arrangement. And a preferred share arrangement basically means if they put in $500,000, let's say, I'm going to try and make a very simple scenario, $500,000 for a $2 million valuation, okay? If they were investing for the same class of shares as the founders hold, which are typically straight commons, So let's do that scenario for straight commons. They're putting in $500,000 at a $2 million valuation for 25% of the company, okay? Let's say a year later, the company sells for $500,000, okay? How is that getting split? They're going to actually take 25% of the $500,000 for the 25% ownership, and you, as the founder, you'll keep 75% of that $500,000 exit value, right? Now, if they had actually taken preferred shares, and I'm trying to keep it very simple kind of basic preferred shares, for the same $500,000 at a $2 million valuation, 25% of the company, if the company gets sold for $500,000 a year later, the investors get their full $500,000 out first, and the founders get nothing. It sounds really odd, right? Because you're like, oh, hold on, $500,000 is for 25%. Well, no, because they get preference on a sale of the company or a liquidation of the company, which means we will get our money out first, and then whatever's left over beyond the 500,000 gets split 25-75 between us and the company. Now, this is a very standard, this is called basically a simple preferred, participating preferred share. So, let me see that. Okay, I'm just trying to keep a timeline. Okay, so a couple of quick term sheet tips. Get a lawyer. I mean, unless you're really an expert at financing and financing terminology and what this all means, at the point where you get a term sheet, if you haven't engaged a lawyer before, please engage a lawyer. Don't sign the term sheet and then go engage a lawyer, okay? A lot of the key deal terms will be in this term sheet. Do we have time? How much time do I have?
How much you need?
No, I'm just trying to think whether how much time. So let me, I guess the only, this is a fairly quick point. I mean, just pre versus post money valuation. I don't know if this was mentioned actually by any of the previous speakers. So when you say a company is valued at $1 million, there's two different ways of looking at that $1 million valuation. If it's a pre-money valuation, so let's say you're doing $500,000, again for simplicity's sake, you're raising $500,000 at $1 million valuation. If you're raising the $500,000 at $1 million pre-money valuation, what that means is that the investor is not actually getting half of the company. The investor will actually get 1/3 of the company, because the $1 million valuation is pre-money, which means actually the valuation post-money valuation is $1.5 million. In other words, once the investor's money actually gets accounted into the equation, you're looking at $1.5 million, 500,000, so they get 1/3. So just be careful with that. I mean, typically you'll see, there will be some reference to pre or post money valuation in the term sheet, but you just want to make sure that if it's not there, that there's clarity, because the impact can be important, right, from a company's perspective. The other point I wanted to make is always make sure that you have a cap table attached to the term sheet. And the cap table basically sets out the actual share numbers, because you don't want to talk about percentages, you want to talk about actual share numbers. I don't want to get into too much detail on why that matters, but just make sure that you spend that time and you with your lawyer and with your counsel. And if you don't have a cap table in place, put a cap table in place, attach it to the term sheet and say, okay, you're putting in $500,000. This is how many shares are outstanding today. These are how many shares you're going to have post-closing, right? I already talked a little bit about the preferred shares. And then, as I mentioned, it's great news that you got a term sheet. They send it to you. Let's say you do some negotiation on some of the terms with your lawyer's input. You sign off. Typically, you're looking at anywhere between 2 to 4 weeks. Again, 2 to 4 weeks to close, which means to sign the actual definitive binding contracts for the investment and receiving the funds in your company's bank account. Again, when I talk about 2 to 4 weeks, as with all closings, sometimes they tend to move back, right? so you might be looking at 2 to 4 weeks and it might end up being 2 months, but that's typically the target, especially for the large institutional guys. They want to move really quickly. They want to get the money into the company, and they just want to plow ahead. So typically it'll be a pretty kind of tight timeline there, and you're going to be spending a lot of time with your lawyer, unfortunately, during those 2 to 3 weeks reviewing all kinds of documents. And of course, during those 2 to 4 weeks, there'll be additional due diligence that will happen on the company. And of course, again, I'm kind of referencing the whole exclusivity situation. So what the investor wants to make sure is that during the time up until the closing, there's no other kind of discussions happening. And then just, you guys don't really care about this, but the main 2 documents that would be signed on closing, sort of in terms of contracts, would be a subscription agreement. And the subscription agreement basically sets out a number of sort of representations and warranties from the company saying, yes, we exist, yes, we've developed this, yes, so essentially attesting to certain facts about the company. And then the shareholders agreement, which will essentially govern, will be the sort of the corporate governance document, if you will, which will set out the investor rights, et cetera, et cetera. There'll be a bunch of other, what we call ancillary agreements in any financing, but those are primarily the 2 main documents that will be negotiated up until the closing. And that's it, and this is a little bit about us, again, but I won't get into it. I'll just take questions because it's quite late.
Questions?
Nobody has a term sheet on the table looking for free legal advice right now? Yes?
I have a question to you. Who normally creates the term sheet? The investor or seller?
The investor.
Investor.
And that's the point I was trying to make before, is that when I'm talking about company offering, so pretty much in all cases when you're dealing with an institutional venture round, it's coming from the investor. So it's always coming from the investor.
So normally, I don't need to prepare any term sheets. So I just...
No. I mean, now, having said that, when you're dealing with sort of, let's say, a friends and family round, so, Matt was talking about sort of the spectrum of investors, talking about friends and family, or even a very small angel round. So let's say you're looking to raise $100,000, and maybe from 3 or 4 people, each putting $25,000. There have been scenarios where you may have a bunch of people that they're kind of friendly people, friendly investors, and you might actually create the term sheet with your lawyer and actually circulate, and that would be kind of an obvious thing. These are the terms under which you're raising money for the company. Please put it on. That's a very different scenario. But once you get to any level of sophisticated investor, the term sheet is going to be coming from the investor.
So another question, class of shares. Like normally, you mentioned the class of shares in term sheet, but we have the class of shares in shareholder agreement. Normally when you create your own entity, right? Is it the same or it's different?
I'm not sure I understood the question, but let me try and explain. Essentially in the articles of incorporation of the company, you'll set up different class structures. When the investor comes on board, they will require you to create a specific class of shares for them. So you have to change. You have to change essentially. I mean, let's put it this way. Whatever you had before is going to change. So whether you had a shareholders agreement, it's most likely going to go out of the window. Or, I mean, if it's a decent shareholders agreement, you might be able to modify it somewhat and bring the investors under it. It really depends on the scenario, but especially if you're dealing with an institutional investor, institutional VC, your corporate documents are going to get changed, and your shareholders agreement is going to be a brand new shareholders agreement. So, yeah. Yes?
So you talked about the percentage of ownership. What about control? So is the control proportional to the percentage of shares that investors are getting?
That's a very good question. The answer is no, right? So the answer is, think about it this way. I mean, if an investor, if a VC comes in and they invest $500,000, again, let's say at a $2 million valuation, post money, and they take 25% of a company, technically speaking, then essentially you'd be owning 25%, and you'd be running the show with 75, doing whatever you want, right? That's not going to be the case. And there's various mechanisms for exercising control as a minority shareholder, and they're going to basically take over, or at least have equal representation on the board, or perhaps take over control of the board. And then the other thing you'll see, particularly in some of the more detailed term sheets, you'll see a whole section called what's called protective provisions, right, or special rights. And essentially what that talks about is, okay, we're 25% shareholders, but there's certain decisions that if the company wants to make those decisions, we have to okay. So here's my money, $500,000. You can't go tomorrow and sell the company, right, without my okay. right? And there'll be a whole list of those things, and they're fairly. I mean, the other thing I want to kind of leave you guys with on that note is, there are intricacies in term sheets, and you want to get input from, somebody who a lawyer who understands, who's done these things, who can take you through it, make sure there's no, hidden things, and at least that you know what it is that you're getting into and you're signing up for, and that it's generally along industry standards. But a lot of the other stuff, like sort of these protected and stuff like that, a lot of those things tend to be fairly well known and accepted in the industry, right? So once you get some of the key field terms in place, there'll be obviously always 2 or 3 main things that are going to get negotiated. But a lot of the other stuff is fairly, well known and well established in the industry. Right?
So on another note, you said I cannot enforce the term sheet to the investors.
Yes.
But once I sign it, they can enforce those, whatever conditions I've signed upon, on me as a company.
They can enforce whatever is the binding provisions, right? So let me put it to you this way. If during the due diligence the investor finds something that they don't like, so for example they find out, the code that's written is really bad code, and actually we thought that the company was at this stage in terms of its IP development, and we're going to have to hire somebody else to completely redo this because it's just garbage, and it's going to take us another 6 months. That's going to impact the valuation, right? They're going to say, sorry, our expectation was that this is what we would find. That's not what we found. We're willing to do this deal with you, and these binding provisions are still there, and we still have this term sheet, but it's not going to be at this valuation. I mean, I'm just picking one example, one extreme example, right? But the point being that from a legal standpoint, you will see, and you'll see at the top of every term sheet, it's very standard language. You'll see, this term sheet is for discussion purposes only, and the only binding provisions will be under these headings of the term sheet.
So you didn't answer my question. Can I revoke it after signing it? Can I take it back? Say no, I'm not interested in it.
You can terminate the term sheet. Yes, you can.
Okay.
Yes, and typically, not typically. Sometimes you will have terms in the term sheet. You can walk away. There's nothing stopping the company.
You can go to a third party while they still have.
Going to third party, but
Yeah.
I can stop the deal.
You don't have to
Yes,
take
yes, you can, but you can't keep them in parallel, right? In other words, you see what I mean? So the exclusivity clause doesn't mean like you're here. I mean, you might, 5 days into it, you might think, oh, geez, I don't never want to do a deal with this VC, right? And I need to terminate discussions just as they can terminate discussions.
Okay,
Okay.
fantastic.
Thank you.